Good morning and welcome to Mo Knows featuring me, Monica Mo Justice. Okay, today's worship oh comes out of an abundance of conversations that I have recently under new conversations to me. Just new conversations to me. So I'm gonna focus on a construct called closure today. And the consequences of not accepting closure as it's been ordained. So if that's something you want to talk about or you want to engage with me on, come on down. Come on in the chat. Let us sort this out. Let me pause. Okay. Hey Taylor, what's up? Oh, let me see. Let me take a moment to see if I could rekindle the let me just hold out for a second. So I done gave y'all the scope of what we're gonna discuss, and I'm gonna take it to my it's thoughtful Thursday, so I'm gonna keep it in thoughts. And that's about it. Hold on a minute. Okay, where are we at? Mo. I'm gonna try to get the chat. Ooh, I might be able to do it. Let's see. Ooh, that is interesting. I had something else start up. Oh, that's what that is. Oh, ooh, that was scary. All right, that was scary. I should have messed with this before I got here. Anyway, yesterday on my way to work, I was reading a good book, um, and reflecting on a conversation I had with the. I, I've had some good conversations in the past couple of weeks that I've been back to taking in the Sabbath and taking a break and then coming back and having a good conversation and doing my Bible study. And one of those conversations I had with a gentleman from the YouTube space, and we were talking about how some people call themselves a god, right? Why would a person call themselves a god? Uh, so I gave my assessment of where they may have. Oh, good morning, Mr. Brown. I gave my assessment as to where they may have gotten that statement from, and we went through Genesis, chapter, what was it, chapter 3, like ain't nobody business. And then he gave me his analysis of where he thought a person would get their statement, I am a god, to even refer to oneself as a god. And it was a good conversation. And what I regret about the conversation is that it is the type of conversation, because it's based on a book, I would love to have on a live stream or on an upload or in my environment altogether. That's what I envisioned when I came here on the YouTube. That's exactly what I wanted to do. And so I was empowered by the discussion because I know that it exists out here. I just haven't gotten to the place where I have people willing to engage in that same conversation. I just have people that were acquainted with me who wanted to break down folks, individuals, but not issues, not uh ways of life and behaviors and things that we could have really had an in-depth discussion about. So in my journey, when I decided that I was going to go back into Sabbath and stuff. Maybe it had to do with turning of age. Maybe a lot of things played its role. Maybe it has to do with new people in my life and new ways that I'm walking, the new path I'm on. So maybe that all plays into it. But there's definitely a point where I have reached closure on some things. I remember when I was a child, and y'all know how this goes. When I was a child, I spoke as a child, and then when I became adult, I put the childish ways behind me. Y'all have y'all scripture for it. Some of y'all have your plaques on it, but we all know what it is. It's called growth. And in life, when you grow up, when you've come through something, been somewhere, and turn up on the other side of it, growth exists. And whatever it is that was behind you, you've managed to leave that behind you. Some people travel in that lane and they call that closure. They've put the past in the past. But are they really closed? Is the issue really closed? What does it really mean? So in that spirit of information, that's where I found myself at. Thinking like that. Oh, hold on. Feeling in those ways and not just explore deeper. Sometimes it's easy for me to explore me deeper. All right, let me get this link. Let me see if it works. Hold on a second. I apologize for this interruption as I try to get the chat. Okay. But I realize I'm not the only one who's dealing with issues of who's having a complicated time dealing with closure or defining what it really means to me and moving on with that. Get rid of this. Let me get rid of that. Okay. All right. Let me go back to this. We got a president of the United States who, former president of the United States, Mr. 45 himself, who could not deal with closure. And as a consequence, he's living the reality of not being able to close. He got the art of making a deal, but he done got the finality on closure. That's crazy. So that's what I plan on speaking on today. So let's see. All right, so now we done move forward. It's going to fade to black for a minute. So let's see where we are with that. Darn. That's where my problems lie. All right. I don't have the energy. I don't have the energy to deal with that today. But I'm going to come back and revisit it. I got to set that up differently. All right. Here's what I read that got me into this mood. Closure is not a destination. Neither is moving on. It's not a period at the end of the sentence. It's more likely to be a conjunction or a comma. Now, don't get all upset with me that this trickles down to librarian type principalities of me, relating to something in terms of English context, looking at closure. I watched at the beginning of this week, I watched Monday the funeral for the late Queen Elizabeth II, the third. whichever number she was, her. With all due respect, I just don't know if it's a second or a third. But at the end of the day, I watched the funeral and I listened to the auditors or whoever ran it give their rendition of where you are at once you die. And I notice in most conversations when people speak of the deceased, they always speak when we meet again. So they too put some kind of closure on the relationship until we meet again. So it either has a conjunction between it or there's a comma, but there's never any finality. So closure is never finality. But when you fail to close relationships and when you fail to bring closure to a situation, all you do is allow it to fester and grow into something else. And that's considered a problem. You know how they say you got 99 problems, but that becomes one of them because you haven't allowed yourself to separate from the situation and take in and absorb the fact that you are moving on. Odd thing happens here in some environments when you meet some people. When they see other folks begin to move on, they can't accept it because, you know, there's a poem about moving on when tomorrow begins without you. They can't accept the fact that tomorrow's moving on without them. They can't begin to relate to the fact that someone has decided and made a decision, made a informed decision that you are no longer part of their destiny in its current format. Some can't accept defeat. It wasn't the loss that one of the things that I saw I'm thinking it wasn't the loss of the election that bothered him. It was one thing that bothered him. It's the loss of power. He was given so much power that he thinks now. And it is. You understand? He thought he was a god. He thought he had all this power, and I'm talking about 45. He thought he had all this power while in office that he really didn't have. And he walked around there believing that he did. And the people around him enabled him instead of empowering him and educating him and guiding him to a successful path. What they did was they coddled his inappropriate thoughts, and it created a monster that already existed. I heard somebody say that the judge in his latest case here in Brooklyn, New York, basically said to him, and this is a special master, and this is what got me yesterday when I was listening to something yesterday morning. They said a special master had been assigned to his case, right? And we know that was going down. I wasn't following this in its entirety. I was only talking to another YouTuber about it, and that YouTuber is Glib, and I wish he come out of bushes, wherever he's at, driving down I-95. I wish he come out of there because, boy, we need to talk. So I had heard bits and pieces of this and never really took up on it. But this bothered me yesterday. They were talking about the special master came to a conclusion that one, this was a request of Donald Trump's, so he would have to pay for the proceedings because this is his case. And I was like, why is it his case? I thought these people had got an affidavit for legal documents. And this is why the stuff wasn't making sense to me. And the reason why the stuff wasn't making sense to me is because it's being explained to me out of context. And someone is explaining to me their side of the understanding of these issues. One, without legal terminology, misuse of legal terminology, and it drives me insane. And then secondly, I never asked any questions to try to get more of the background, because some folks, when they speak to you based on their opinion, and they only want to have a conversation with you as it relates to their opinion on a topic, not from the facts of the topic. I like to go into the facts. So lo and behold, I wake up this morning and there it is in the New York Times for me to read that the 11th Circuit Court, which is an appeals court, has a written decision. And in essence, darn, I should have wrote down the final words of their written decision. Hold on a second. Let me just go to my... Oh. Darn it, I went to the wrong app. Hold on. This is going to take forever. Hold on. Oh, no. So let me just go to my files. Let me go to the final page. I read all 29 pages this morning. It's a good read. Here's the conclusion. And I can appreciate a decision when courts write a decision, because they give you captured points, right? So this one is Roman numeral 4, and it says the final words are conclusion. So we're in this section, like, think of it as a chapter. We're in this chapter of the decision, an appellate decision, and normally an appellate decision is on a decision that a judge makes in a lower court. So that's what this decision is, and it says, for the reasons we have explained, we grant the stay pending appeal. So that means that whoever requested a stay pending repeal, they have granted it. And the district court order is stayed. So now the district court made an order, and they're saying it stayed. And stayed in legal terms means that she's not allowed to proceed. Stayed to the extent it enjoins the government's use of the classified documents and requires the government to submit the classified documents to the special master for review. So that person I was just talking about, the special master, who said you can't have your cake and eat it too, his part has been stayed. So now I'm going to go with what could be the next steps. The next steps, because they didn't tell the lower court anything else other than they granted the relief that was being sought by the appellant in this case. And they didn't give her any special instructions. The only thing that the appealee, which is the plaintiff, could do at this point is go to the Supreme Court. I know I'm going backwards right now, but they addressed that also in this court document. Which I because I read it in its entirety, and I don't got nobody else's voice in my mouth. I now know what was the difference between an affidavit, because I asked the question the other day. I said, "What is an affidavit?" And I got my answers, and I'm gonna bring that to a head. But I want to go to the most severe first, because if you was waking up and you was in Trump's camp this morning, the first thing I would be trying to do right now, if I didn't agree with this decision, is going to appeal to the Supreme Court. But I would read very carefully up in here, where they address the Supreme Court. Here it is. You know, I turned on some other mode on here. Hold on a second, because I turned on, I guess I can't use that. Ooh, where was that at? All right, I gotta leave that alone. I don't really play in this application that much. How did I turn on? I turned on night mode. I want to turn night mode off. Anyway, it says the Supreme Court has recognized that for reasons too obvious to call for, I can't even see this. Hold on. Let me turn it this way. The Supreme Court has recognized that for reasons, and I quote, too obvious to call for enlarged discussion, the protection of classified information must be committed to the broad discretion of the agency responsible, and this must include broad discretion to determine who may have access to it. So the agency that's responsible for it only has the discretion. And these are matters of the executive branch. At this point, the executive branch is the president. But the former president still considers himself the executive branch. You're no longer in that capacity. And that's what the problem is. That has been his failure for closure since the beginning of the morning of November 2nd. He has failed to reach the point of closure. And as a result, reading back to what the Supreme Court's previous decisions have held, these are holdings from the Supreme Court. As a result, courts should order review of such materials in only the most extraordinary circumstances. The record does not allow for the conclusion that this is such a circumstance. Oh, goodness. So they kind of threatened them in their ruling to say, you can go against what we are saying, but the Supreme Court in and of itself has said that this is how stuff should be handled when it is classified. And I learned so many things in this one document that could alleviate conversations for days. Now, don't get me wrong. I understand that glib represents this information from the perspective that Donald Trump is wrong. And I appreciate that. What I cannot follow most of the time is where the argument started from, because he uses terminology like affidavits and so on and so forth. So in this document, which is a decision of an appellate court, which reversed the decision of the district court, is an important document in having conversations with folks, because it gives you the history of the case. So we're going to start with the beginning. I got to turn it this way. Maybe I should have put it on the screen. Hold on. Let me just see if it opens up. I saved it somewhere. I saved it in something called Google. I hate messing with things around here. Let me see. I saved it. So where would I have? I know where I saved it at. I don't know if it's there. We'll find out. What did I call it? I had a folder called No, it's in Google. Hold on. How do I get to the Google one? I think I need to be in that damn Chrome thing. Hold on, let me go find Chrome. All right, I'm going to Chrome. Please hold while I look, because I cannot sit here and do this. That I cannot do. Hey, Monica Mo Justice, how you doing, girl? What's up, girl? So wait a second. So now, what does Google store your stuff in? Oh, I think that's where it is. Google Drive. Let's go there. I think that's where I put it. That's exactly where I put it. Girl, you go, girl. You go, girl. I need to open this. All right. Now let me see if it got any identifying things on it. All right. Okay. If I open to Google Docs. Oh. Hold on a second. Oh, yeah. All right. Tell me how this looks. I hate doing things around here. Let's be dangerous. Let's see what this looks like. Hold on a second. Oh, it's got my highlights in there. Does it say Monica Mo Justice? It certainly does. I should have put oh, man. To be continued. To be continued. Oh, I gotta work this out. Oh, y'all not gonna be able to see it like that. All right, hold up. That's all right. Y'all don't need to see it. Y'all need to know it's there. Go read it for yourself. Because right now, Momo is going to try to read this for herself. Hold up. But let's see. Can we open this more? Wait, does it say full page anywhere? Those people that like to be nosy in other people's stuff, tell me what y'all see. Oh, this is going to drive me crazy. It's thundering and lightning outside. Okay, oh, I'm glad what is this? If I hit this button, I wonder what it's gonna do. Let me go hit this button over there. Look, I gotta go try things over there. Oh no. Look, I gotta go try things away from y'all, because y'all know y'all be doing too much. All right, let's do this. Y'all don't need to see me, right? Nah, y'all don't need to see me. So we are going to do this. Booyate. That makes sense to y'all? Oh, wait a second. Wait. Boop, boop, boop. Let me see what's on that screen. Hold up. Let me go back over there. Look, I gotta be watching y'all because y'all be nosying in people business. All right, I think that looks bigger. That looks bigger right there, right? That looks bigger. We doing better. Okay, here we are. Okay, so here's the thing. Go Momo, you doing some business today? Yeah, he's barking because of the he doesn't like thunder and lightning. It's thunder and it's lightning outside. All right, so here is the decision. And the first thing you see in the decision, in the first page, they normally summarize everything that you need to know. You don't even have to read the whole thing if you're not an avid reader in an opinion of the court. They give the history right here. They said, following the execution of a search warrant at the residence of the plaintiff. So he's the plaintiff in the district court's case, and he's the appellee. He's the appellee here. He's the one responding to the appellants here. So although he filed the complaint in district court, he's the plaintiff there in district court. But when the defendant in district court files into the appeals court, the defendant becomes the appellant and the plaintiff becomes the appellee, which means he would be he's defending, or whatever decision is being defended here, he's the appellee. It sounds just better to say he's the plaintiff in the case and the government is the defendant. And the defendant filed an appeal and the defendant is referred to now as the appellant. Okay, so now the plaintiff appellee, former president, moved for an appointment. So when they use the word moved, that is a motion. So he filed a motion in court, not an affidavit. It's a motion. He filed a motion. Now somebody's going to come back and be like, but it's an affidavit. It's a motion. So he moved for the appointment of a special master to review the documents that the defendant, the United States of America, seized. So this is how they got in court. This is not any basis of they went in, raided his house, and then they went to court. That's why I was so lost. I was like, so why are they in court again? I don't understand why they're in court. Oh, they're in court because they issued a warrant, a search warrant, right? That they got probable cause to execute. They executed a search warrant that they got probable cause to execute. And the person that they executed it against filed in court basically saying, the stuff they took from my home, I want it returned to me because it belongs to me. And that is the issue at play. That's all this is about. So I don't understand why it's a bunch of arguments with people. I don't understand why anybody would be arguing with Glib about this, because this is simple. The government got a warrant for some documents, and we'll get into that. But the government obtained a warrant. They went in, they got the documents, and when they got the documents, the word is called seized. They seized the documents. And when they seized the documents, this dude got upset and said, I want my documents back. And this is a simple argument about which documents belong to him and which documents should he get back. And because the documents are classified, and there's 3 categories that the documents can be classified as, right? They got some language for that in this document that you'll hear about. They got 3 classifications. I don't remember them off the top of my head. I know one is top secret, but they got 3 levels of classification. And all they saying here simply is that the documents that are in question are not his documents. And the summary of it is he wants, and the lower court has granted the plaintiff, or at this level, the appellee. The lower court has granted the appellee part of the case and said, okay, listen, they can no longer look at the documents. They can no longer look at the documents. That's what happened to him. The court ruled, the lower court ruled that stop government. You can't look at the documents because, and this sounds so stupid, I have to determine if they're attorney-client privilege, if they belong to the appellee, if they belong to the plaintiff. And in order to decide if they belong to the plaintiff, I must assign a special person to look at these documents and see if they belong to the person or if they belong to you, the state, the government. And in the interim, you, the government, cannot move forward in your criminal case, but you can move forward in your other investigations. So she limited them, and you cannot move forward in your investigation if it's going to lead to criminal investigation of this man. You cannot move forward on that. That's in essence what happened here. That's what I read. So here it goes. And you can read this for yourself. It's 29 pages. It's not that complicated. We'll try to do it today. Now, now the United States moves. So the first person that made a motion was Donald Trump's, the plaintiff made a motion to appoint a special appoint a special master. In your question, Eric Brown, I'm going to read your question. It says, was it the U.S. Marshal that entered his home? I don't know. What I do know, I don't know who specifically entered his home. What I do know is that they was authorized to do so. So they had the proper authority to do so. So if it was the U.S. Marshal, so this is where, like, and this is what happens, and this is why YouTube platforms and stuff have problems, because in their processing of information, like I'm doing right now, people come in and ask questions, or people make statements that are being transcribed by the YouTube. And if it's contrary to the actual authoritative news, it could get you in trouble with YouTube, because it may appear that you are providing misinformation. So I want to stay focused on actually what I'm reading, and only stay within the parameters of what I'm reading, so that I can stay in compliance with the YouTube mechanism of only providing commentary towards authoritative news, not making up my own news. So I don't know who entered his home, and I don't recall reading in this document who did. Okay, but what I do know is we're going to go through this, and it'll tell you where those documents came from. So here we go. Now the United States moves for a partial stay of the district court's order as it relates to roughly 100 documents bearing classification markings. So what they're saying in essence here is that they're not asking to throw out everything the judge said. They're only asking for a small focus, and it's on the 100 documents that state they are classified. We decide, so we here, when you see the word we in this, right? Monica, don't do that. I'm going to be so mad at me. Hold up. Oh, I'm so mad at me. Hold up. Oh, I'm so mad at me. Hold up a second. I got to figure out. Hold up. No, we're not about to do this. Karen, you were supposed to help me how to use this. You know I don't know how to use this. What the hell? Hold up, I gotta look at something again. Oh! Oh no, I'm not gonna read it like that. All right, we're gonna go back to this. Cause y'all know I got it. Ah, thank you for that support. I appreciate you. And you didn't even have a title. Okay, one second. Mo, could you please get this together? I'm trying to get rid of that little stupid thing. Ugh. Oh, I'm gonna be so. This is gonna drive me crazy. Everything gonna drive me crazy because I am not this professional. Okay, Nugget, you gotta cut it out now. You gotta cut it out. There's no reason why you still crying. All right, so this is it. Okay, so they asked for 100 documents. We decide. So we is this court right here, the appeals court. Decide only the narrow questions presented. And here's the questions. Whether the United States has established that it is entitled to a stay of the district court's order to the extent that it, 1, requires the government to submit for a special master's review the documents with classification markings. So they have identified documents with classification markings. And this is now what I am going to assume is going to be the next steps. Once they take these documents, all this other judge would have looked at and said, hey, does this have a classification marking? Oh, it does. So I can't look at it. All he's going to do is look at it and say, all right, here's document 1. Here's document 2. This one says classified. Oops, can't open that one. This one doesn't. Well, what is this one? But the government has moved that all of the documents that they're presenting to this special master, 100 of them, all are classified. I gotta make this make sense. So all of the documents are going to read classified. And then this one might not. But they're saying we've identified all of the documents, 100 of them, all of these documents in question. And they're all going to say classified. So the question was he going to open them to make sure they were classified? But he's only looking at the thing that says that. Okay, so as it relates to roughly over 100 documents bearing classification markings. Dude, I was talking about you all morning. Okay, so we decided only the narrow questions presented, and that's to the extent that it requires the government to submit for the special master's review the documents with classification markings, and 2, enjoins the United States from using the subsets of documents in a criminal investigation. We conclude that it has. So right there, whenever you're reading a decision of an appeals court, in the first paragraphs, they give you their findings. The other paragraphs support their rationale as to how they came to their findings. And they normally use holdings from other court cases. Eric Brown, these are the documents. So when we work a job, right, and Donald Trump had a job, it was called President of the United States. And then sometimes in your job, for those of you who have a job, you are given the authority over something. And in this particular case, in this particular instance, as the President of the United States, he had access to classified documents. And we're having access to the classified documents when he was no longer president. He no longer has access to classified documents. But at this point, he did. At one point, he did. And then when he left. So imagine you work a job. So let's just all, those of us who work or those of us who dream about having a job one day. You go to work and the employer has some documents that belongs to the employer. For some of you, you will work at McDonald's, okay? And McDonald's will issue you a uniform, right? Maybe, and it'll say Mickey D's on it, right? And it belongs to McDonald's. Donald Trump was president, and he had documents that belonged to the government that he was responsible for. And when he left, he took it with him. So imagine the McDonald's employee leaving Mickey D's with their uniform. And the company says, give me back my uniform. The government said, give me back my documents. They're no longer yours. You no longer serve in that capacity. Therefore, you are not authorized to have them. And if you're not authorized to have them, woohoo. Okay, so that's where we are at. That's the breakdown. An ex-president can have access to the documents if given by the current president. The only way an ex-president, and that too is in this document. So again, interesting enough. So, and these are the arguments that I say you do, Glib, that I can't fully appreciate. Just what you just said. Ex-presidents can still access classified documents. They can only access classified documents with the current executive branch's authorization. So it doesn't matter that they, oh man, I wish I could pin the comment. I'm so mad right now, but I don't feel like messing with OBS to deal with it. They cannot keep them. They cannot access them without, once you leave office, once you leave a position in any company that you work in, once you leave that, come on, Glib, you worked for the military. Once you were no longer in the military, you couldn't walk into a military building and still have access to military stuff. You could not, once you no longer worked for the military, maintain military files in your house. So don't do that. Please don't do that. That's not nice. That's not nice. The United States from using a subset of documents in a criminal investigation, we conclude that it has. So what it has is that we decide only the narrow questions presented, whether the United States has established that it is entitled to a stay. And they say we conclude that it has. So that is what that's connected to. And the reason why I'm pointing this out is because I've seen people have arguments made on this YouTube to glib based on the things that they've read in the decision. So I'm just pointing out where things connect to things. I'm going to restate what I said before. A former president may have access to classified information with the consent of the new administration or the current administration. So here's what I'm saying specifically. A Jimmy Carter, who is still alive, is a former president. He may have access to classified documents if the existing president grants him that. That's my final answer on that part of it. It's with consent. When you're no longer in office, no one's bringing you classified information. No one's giving it to you without the authorization of the current president. And that's from any administration to any administration. The Republicans could be in office 2 years from now, and guess what? They can deny every Democratic president access, any former Democratic president access to anything, and only give information, classified information to their Republican former presidents. At the end of the day, what I'm saying, Glib, very clearly, is that that's not the issue at hand right now. That is not the issue, and that's not what I'm discussing right now. I'm not discussing can he have the information. This right here, this whole court case is stemmed around the fact that he would like the documents that were seized in his home returned to him. And this courts are now determining what, in his interest, what belongs to him. That's all this is about. The government came in and seized materials from his home, and they're just trying to determine which ones rightfully belong to him. Okay, so we stress the limited nature of our review. Again, they are clarifying. They're not making decisions based on the arguments of the case. They're making decisions based on this narrow question presented to them. The matter comes to us on motion for a partial stay pending appeal. So what they had asked for of the court, of the appeals court, is for a partial, well, they had asked the lower court for a partial stay on something pending appeal. And she moved forward. The lower court moved forward. So they appealed. This is the appeal. We cannot and do not decide the merits of this case. We decide only the traditional, equitable considerations, including whether the United States has shown a substantial likelihood of prevailing on the merits. The harm, so then they're telling you what they decided. And later in here, they tell you based on what laws they're deciding it on, what prior holdings they're deciding it on. Including whether the United States has shown a substantial likelihood to prevail on the merits, the harm each party might suffer from a stay. And in their analysis, they tell you, they break down what damages or what suffer, say, the plaintiff or the appellee in this situation versus the defendant or the appellant in this situation. Okay, so and where the public interest lies, because there are three people, or there's three entities. There's the former president and his interests, there's the government's interests, and then there is the public's interest, which is national safety. In this instance, what they are considering is those components. For the reasons we explain below, we grant the United States motion for a partial stay pending appeal. Here's the background, and this is what is very important. It's the background. And I did something that I'm so proud of myself that I did. I actually annotated these so I could just go into my talking points. So the first thing starts with this paragraph right here. In response to these requests. All right, so what were the requests? Let's just go. I'll take it to you step by step. So first, the plaintiff left the White House in January 2021. Okay, so he left the White House after serving as president of the United States. Upon leaving the office is the president of the United States. It's a job. Movers transferred. Notice how they specify who moved the documents. Very important. Upon leaving office, movers transferred boxes of documents to his personal residence in Southern Florida. So the reason they state Southern Florida is because this is showing jurisdiction. Southern Florida is where this took place. It's being heard by a judge who's in Southern Florida. And as a result, this is being appealed to 11th Circuit. The 11th Circuit Court covers Alabama, Georgia, and Florida. Go Momo! Go Momo! Get your facts on. Get your facts on. All right, just had to do that. Okay, anyway. Just giving y'all some basics on the court structure. So jurisdiction has been covered in that paragraph. The record reveals the record. So these are the facts. Only the facts. Nothing but the facts. Throughout 2021, and consistent with its responsibilities under the Presidential Records Act, the National Archives and Records Administration sought to obtain records in plaintiff's possession. So somebody was responsible for these records. They noticed that the records were not there, so they sought to obtain the records in the plaintiff's possession. In response to these requests in January 2022, so that is 1 year later, okay, plaintiff transferred 15 boxes of documents to the National Archives. Okay, the National Archives reviewed the contents of the boxes and found inside. So they tell you what they found: newspapers, magazines, printed news articles, photos, miscellaneous printouts, notes, but also presidential correspondence, personal and post-presidential records, and a lot of classified documents. Eric, if you stick around, your questions will be answered in this document. It's all listed in this document. Affidavit in support of an application under Rule 41 for a warrant to search and seize. So this is where affidavit was put together because they needed a warrant. So in order to get a warrant, you have to swear out that the information that you are presenting to the court is factual. That's where the word affidavit comes in, and that's what the activity they engage in to the court to get a warrant to look. It is not the same as Trump filing in court to receive his documents. That's not an affidavit. This is an affidavit when the court, when the records people notify the National Archives, takes this steps. An affidavit in support of the application under Rule 41 for a warrant to search and seize. Consequently, the National Archives sent a referral by email to the Department of Justice on February 9th, 2022. So they start putting dates up in here. Upon learning about the classified materials, because see what they said here? They said they received 15 boxes, and amongst those things were a lot of classified records. So if the archives got them, where aren't they? They aren't now in Donald Trump's house when this warrant is executed. He already handed those over, which gave the people probable cause to think that there was more. That's what a reasonable person would come to the conclusion of, and they would ask for permission to seek further. And I'm going to show you why they asked for permission to seek further. It's contained in these responses. So the National Archives sent a referral to the Department of Justice in February 2022. Upon learning about the classified materials, the department sought access to the 15 boxes in part. So the FBI and the others in the intelligence community could examine them. The National Archives responded by advising plaintiffs. So they reached out to Donald Trump and they said on April 12th, 2022, that it intended to provide the FBI access to the records the week of April 18th. So let us stop right there. They received the documents from Trump. They make a notification to the government. Listen, we got these documents from Trump and they contain classified information. And the government said, well, let us see it. And they wrote the plaintiff and said, we're going to allow the government access to what you sent us. So now here we go. When plaintiff requested an extension of the production date to April 29th, the National Archives held off on sending the documents to the FBI. So let's talk about that again. So they got these documents. They let the government know they had the documents. Or let's say they let the FBI know so we could pinpoint a government agency. They let the FBI know and the intelligence community know they had the documents. And they set up an appointment for them to come and view the documents. And they made notice to the plaintiff, Donald Trump, we're going to allow them access to it. And the plaintiff, Donald Trump, said, whoa, hold up, wait a minute. Can you extend that to this point? So they said, all right. And they did. So it says the National Archives held off on sending the documents to the FBI. On that date, plaintiffs asked asked for another extension of time and informed the National Archives, listen to what they did, if it declined to grant their extension. So they already got one extension, and then they asked for another one, and then they threatened them. If you don't extend it, here's what we'll do. He would make a protective assertion of executive privilege over the documents. This is where the jokes come into me. He's no longer in the capacity of president to make an assertion of executive privilege because he is no longer an executive. He is no longer holding that seat. That's a fact. That's a factoid. Okay, moving on. On May 10th, the National Archives informed plaintiffs' representatives that it had decided not to honor the plaintiff's protective claim of executive privilege and that it would provide the FBI access to the records as early as May 12th. So notice, they're putting him on notice. They're giving him a time period because he has the right to do what? He may have the right to do what? Respond. Maybe he could have went in court. Maybe he could have stopped this. But let's see what he did. The letter noted that the president, listen to this, that the president, no, not the president. The letter noted that President Biden has deferred to the National Archives' determination that executive privilege did not apply. He deferred to them. Interesting. Advocating power. Despite this advance warning, plaintiff made no effort to block the FBI's access to the documents at that time. So, during a preliminary review of the documents between May 16th through 18th, 2022, the FBI found 184 documents marked as varying levels of classification, including 25 documents marked top secret. The FBI also developed evidence that more boxes containing classified information remained at plaintiff's residence. So I'm saying this because I seen somebody argue they developed evidence. When you use the terminology developed evidence, that means that they came upon some more evidence to support their belief that there may be documents still at the president's mansion. Now, I'm not going to go into why because I've seen too many pictures of stuff. I'm just going to stick to this document. So I'd appreciate if we all do the same. The department obtained a grand jury subpoena directed to plaintiff's custodian of records and requested documents or writings in plaintiff's custody or control bearing classification markings. So the department obtained a subpoena directed at the defendant, whoever, it says the plaintiff's custodian of records, and requested all documents or writings in plaintiff's custody or control bearing classification markings. So the subpoena was probably a ducus tecum, I never could say that correctly, asking them for documents that was still in his custody. So this is where the request was made, because they saw these other documents in these boxes and they gathered some more evidence that support that there might be more documents. And they didn't just go in and say, oh, wait a minute, We know he's got them. They asked him for it. So this is a point in crime cases when somebody says, do you have anything else of ours over there? Do you have any of the stolen property in your house? And this is what happened next. Plaintiff's counsel was served with the subpoena. Okay, so then plaintiffs sought and received an extension in time to produce the subpoena documents. So notice a pattern of behavior here. Whenever they're asked for something, the first thing they seek is an extension. So it seems like there's cooperation at play. Next up, after initially denying the request, the government extended the compliance deadline until June 2022. On June 3rd, 2022, in response to the subpoena, plaintiffs' representatives produced an envelope containing 38 such documents. So they actually affirmed the FBI's assertion that they had, what was that word? Developed evidence that there was more. And to that end, these people produced more. After initially denying, this thing is just crazy. In response to, so they came up with an envelope containing 38 such documents, and in that, they got that information from the warrant affidavit. That's what that's saying right there. At the same time, his representative stated that she was authorized to certify. So she gave a certification at this point that and they quote, diligent search was conducted and that any and all responsive documents accompanied the certification. I am currently reading the appellate court's decision yesterday that stayed this special master, whatever they're calling that person. That's what I'm reading. The envelope contained classified documents, including 17 marked top secret, and was double wrapped in tape, consistent with handling procedures for classified documents. Warrant affidavit. So they got that from the warrant affidavit. Plaintiff made no claims of privilege for his production in response to the subpoena. Critical statement there. When he was handing over these documents to the government that he had in his possession at that time that were classified, he was not declaring privilege on those documents. Anything he voluntarily gave them, he did not scream privilege. Despite plaintiff's production in response to the subpoena and counsel's representation that a diligent search had occurred and all responsive documents had been produced, the FBI developed evidence that more classified documents remained at plaintiff's residence. In August 2022, the department, through an FBI agent's sworn affidavit, informed a magistrate judge of the evidence it had developed, and the magistrate judge agreed that probable cause existed that evidence of possible violations of the law would be found in plaintiff's residence. Based on this evidence, the magistrate judge issued a search warrant for plaintiff's residence. When the FBI executed the search warrant, it seized 33 items of evidence, mostly boxes, containing approximately 11,000 documents and 1,800 other items. Among the boxes, 13 contained documents with classification markings, and 3 classified documents were found in plaintiff's desk. All told, the search uncovered over 100 documents marked confidential, secret, or top secret. So those are the 3 classifications: confidential, secret, or top secret. In accordance with the protocol, which in this decision, they break down what that means. In accordance with the protocol that the magistrate judge had approved in the search warrant, the department directed a privilege review team. So this is what the government did once it decided. And look what this review team was comprised of, how they found these people. They were composed of agents not otherwise participating in the investigation. So these are independent agents, not people already engaged in this, to review certain seized documents for attorney-client privilege. Based on this review, the privilege review team identified and segregated. Segregated means moved away from, took them out. An initial subset of 520 pages, not documents, pages, okay, that might contain privileged material. While the remaining documents, members of the investigative team found at least 2 instances of potentially privileged material, which they delivered to the privilege review team. So now they're telling you that they looked through these documents and they found some documents and they gave it to the privilege review team. And then what was left, they went through those and they found some more stuff and they gave it to the privilege review team, evidencing that if in their review they find something that doesn't believe, so this is a good faith offer, that even as they continue to look and they go through things a little bit deeper, if it doesn't pertain to them, they are sending it to the privilege review team to see if it's eligible for privilege review. So they're showing what we call due diligence. Procedural history. 2 weeks after, Glib, it is going to be exactly the same thing. You know why? Because this is a court decision. And in this component of the court decision, this is the history. So the court is explaining to you, again, the history that they considered in making their decision. That's why facts matter. And that's why conversations are important. If you go based on facts, you can have an argument surrounding facts. And it could be intelligent, and it could be it's more comprehensive. So at this point, they're explaining how they got to their decision. We're on B. They're talking about, that was the history. So now B is the procedural history. So the other one was the background, and this is the procedural history. 2 weeks after the execution of the search warrant, this is what's important to me. The plaintiff filed a motion in the district court asking for it to. And we'll break down what it asked for. So the warrant and all this other stuff and having this material and all this other stuff, this is what the government did. This is what the government had. This is as far as the government got. Now, this was Trump's plan to stop the government. He went in and filed a motion, not an affidavit, a motion in district court asking it to, number 1, appoint a special master. Number 2, enjoin further review of the seized materials until a special master was appointed. In legal definition for enjoin is an injunction. And an injunction is when you stop something from happening. So that's what the word enjoin means. Because I don't want people to think that it means joining in on something. No, they're asking for an injunction to stop something. That's the enjoin. So it is to enjoin. So that is an injunction stopping them from further review of the seized materials until a special master was appointed. And require the United States to supply a more detailed receipt of property. And 4, require the United States to return any item seized that was not within the scope of the search warrant. So in essence, you use language like that to talk. So if the government was looking for classified documents that were either confidential, secret, or top secret. What was the other word? It's confidential. I want to make sure I have the wording right. Oh, yeah. Confidential, secret, or top secret. So they basically said, if you don't have anything that is classified, because I'm sure that's what the warrant was looking for, something that was classified, which could fall under the category of confidential, secret, or top secret, return it to us. That's what they asked for. Appoint a special master, stop them from reviewing the documents until a master is appointed, require them to give a better listing of what they got, give us more detail on what they got, and return anything that wasn't part of the original request. Most of this is reasonable. I don't see any problem with what they asked for. I don't see any problem in what they asked for, as it is pointed out here. They asked for a special master. They asked them not to allow them to look at anything until a special master was appointed. They asked them to return anything that didn't belong to them. And they asked them to give a better accounting of what they got. That's all reasonable. This is what reasonable. So this seems like on the up and up to me at this point. Regarding jurisdiction, among other bases, plaintiffs asserted that the district court could appoint a special master under its supervisory authority and its inherent power. See what could have happened? This judge probably could have looked at the documents herself. But she didn't want to take on that responsibility. She too busy doing all this other craziness. So she decides to get somebody else later on down the line. Anyway, the United States made 3 primary arguments in opposition. So in opposition to those 4 things, this is what they said. The United States argued that the plaintiff lacked Fourth Amendment standing to seek relief because he did not have a possessory interest in the seized property. Basically, it's not your property. What we took didn't belong to you. Nothing belongs to you. We took back our stuff. So imagine this is like OJ running in there and trying to get his stuff back. This is basically it. They took back what they say belongs to them. Oh, moving on. In support of this position, the United States asserted that the seized records were presidential records which properly belonged to the people of the United States, not to the plaintiff. Now, this court document quotes something later on which clarifies that for me in my head. Second, this is the second argument that the government made. As to the appointment of a special master, the United States contended that, one, appointment of a special master was an exception, not the rule. So it was like, this is not what we normally do here. So it's not procedurally something that we do. It's in rare occasions that we do that. A special master was neither necessary nor appropriate to address whether certain documents were subject to executive privilege, because plaintiff could not assert executive privilege against the executive branch. He's not a member of the executive branch. He's not an active member of the executive branch. Even if he could, and this is where it even gets funnier. Even if he could, the privilege would yield to the United States need to investigate a possible crime and the United States compelling interest in sensitive and highly classified documents. 4. Appointment of a special master would be inconsistent with the equitable principles, given that the plaintiff had not, as required, turned the records over to archives in the first instance. And 5, the case did not involve complex or voluminous records, so a privilege filter team was appropriate. Okay, so these are their positions. Doesn't mean that the court agreed with all of their positions, but it is stating here what their position was. Third, as to injunctive relief, the court, so this is that enjoined stuff, the United States argued that, 1, the plaintiff had waited too long to seek relief. The department's review of the documents which plaintiffs sought to avoid had already occurred. Plaintiff was not likely to succeed in the merits of his claims of executive privilege. And 3, the merits of his claim of executive privilege, because he did not have any claim to executive privilege over the documents. He had no right to them. He had no right to them. And 3, the harm to the United States. Now, these are their arguments. And you will hear how the court either agrees or disagrees with their arguments later. But they're just presenting to you what they considered. So the harm to the United States in the delay in its investigation far outweighed any injury to plaintiff because of the risk to national security. Boolah, boolah. When a court sees words to risk to national security, no one wants to be the judge that allowed something to be a risk to national security. Plaintiff replied that he had Fourth Amendment standing because the characterization of the documents went to the merits of his claim, not his standing to raise it. While plaintiff appears to view appointment of a special master as a predicate to filing a motion under Rule 41, he disclaimed reliance on the rule for the time being, saying that he had not yet ruled a 41 motion. He had not filed a 41 motion. And so the standard for relief under the rule was not relevant to the issue to whether the court should appoint a special master. So they did shenanigans with the whole process. As I said earlier, more delay tactics. The district court granted plaintiff's motion in part. As to jurisdiction, the district court first concluded that it enjoyed equitable jurisdiction. It enjoyed equitable jurisdiction because plaintiff had sought the return of his property. What is his property? Are the classified documents his property, or are they the property of the executive? And he sought the return of his property under Rule 41, which created a suit in equity. Because its jurisdiction was equitable, the district court explained it turned to the Ricci factors to decide whether to exercise equitable jurisdiction. And then this is where it gets funky, because from this sentence right here, you see they say the district court explains in her rationale that she used the Ricci factors. Okay, and they're going to reverse her. They say she erred in her opinion of these factors. So in law, there's elements that you have to prove in everything, and they have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. They have these factors in it. So she names what she used as her consideration, which is the Ricci factor, and then she breaks down why she believes they met it. And this document and this decision, they break down why she didn't. Or why they didn't, why the plaintiff didn't, and why the district court was wrong. Remember, this is not personal. These are entities right now being sued. So none of this is personal. This is just the rule of law. For the first Ricci factor, callous disregard for plaintiff's constitutional rights. Now, this I don't understand, because they went into a court and they got a subpoena. I mean, they subpoenaed the documents. They did everything they could do respectfully of the plaintiff. So let's see what they said. The district court found no evidence. So she agrees. Found no evidence that the United States had engaged in that type of behavior. So that's one factor not met. As to the second factor, so it's not clear here if you need to meet all the factors, one of the factors, some of the factors, but they went on to the second one, or the lower court went on to the second one. As to the second factor, plaintiff's interest in the need for the seized property. The district court determined that plaintiff had an interest in at least some of the documents, like medical documentation, tax correspondence, and accounting information, but it made no finding that plaintiff had a need for the classified documents. But here's where I have my little issue with it. That's why they would need a special master to make sure that the things that are listed as classified are listed as classified. But it only hurts the prosecution if later on they utilize any kind of documents that they got from there against him, when they just make a problem for themselves, as I see it. The third factor the district court reasons weighed in favor of exercising jurisdiction because, in its view, plaintiffs suffered a likelihood of irreparable injury in the form of improper disclosure of sensitive information to the public and the threat of future prosecution and associated stigma. So basically, he talked about being defamed by them investigating him and having his documentation. He was afraid of what might happen. What might happen, he was afraid of. So finally, the district court concluded that the plaintiff had no alternative remedy at law because otherwise the United States might just retain the property indefinitely. Based on the 4 Ritchie factors, the district court agreed to exercise equitable jurisdiction. Next, the district court held that the plaintiff had Fourth Amendment standing to seek a special master because he potentially had a possessory interest in the records. The district court reached this determination because the court said it was still undetermined whether the seized records were personal or presidential. On the merits, the district court deemed a special master warranted, given that 1, the United States had found at least 2 instances in which the privileged review team reported that members of the investigative team had been exposed to privileged material, and 2, a special master might be perceived to be more impartial than the privileged review team. As to executive privilege, the district court positioned that plaintiff might be able to assert executive privilege against the current president. A former president asserting executive privilege. That sounds like when Glib came in and said he can have access to it. Woof. And the court continued the fact that the privilege review team hadn't screened for executive privilege further all bad, in the words of somebody, another YouTuber, another famous YouTuber up here. Good morning, Miss Natural New Orleans. Finally, the district court enjoined, so we know that's an injunction, the United States from further review and use of seized materials for criminal investigative purposes, but allowed it to review and use the material for purposes of intelligence classification and national security assessments. So that's what I was talking about earlier. She limited what they could do. She limited to, y'all could look at these documents and review it in the sole capacity of national security's interests, but you cannot look at these documents in tandem with a criminal case against the plaintiff. And the states, the government's position. I'm sorry, I keep saying the states, but the government's position is, they are in tandem. If we're doing a case, we're looking at it. If we're investigating something, we're investigating in its entirety. We're not going to just stop here because, that might turn criminal. We only want to look at, no, we're investigating in its entirety. You are now stopping me from investigating in my entirety. You're preventing me from doing my job, and you prevent me from doing my job. And that's what they basically said. After the district court issued its order, the United States moved for a partial stay of the order pending appeal as to the limited set of documents. So, again, down to the 100 documents that were marked as classified. The United States argued that the plaintiff did not have possessory interest in the classified documents because they belong to the United States, not to him. 2, such documents could not possibly contain attorney-client privilege information. And 3, even if plaintiff could assert executive privilege over some of the records, that privilege would be overcome by the United States demonstration specific need to review the classified documents to see if and how much of a risk to the national security existed. As to executive privilege, the United States noticed plaintiff had not asserted executive privilege in response to the May subpoena. Instead, he had produced documents, and his custodian had certified that he had produced all responsive documents, which meant that he had not assert executive privilege over the documents that he was supposed to have already produced. I don't really know if that matters that much to me, because I'm just like, what do you got now? Are they his? If it's not his, then he can't do anything about it. And I think this is what this boiled down to. So the United States argued that it needed a stay in the district court's injunction against the criminal investigation. The criminal investigation and national security were intertwined. They are one. So the government emphasizes. So the district court order prevented the United States from effectively reviewing the documents for national security risk. So they're basically saying we can't do our due diligence here if we can only do a partial investigation. In support of that position, the United States attached a declaration Okay, so they put a declaration. This is serious right here. From some dude in the counterintelligence division of the FBI named Kohler. All right, so his declaration explained that since the 9/11 attacks, the FBI integrated its intelligence and law enforcement functions, which when it exercises its national security mission. So this here explains, and they quote different documents of how they conduct their investigations. So, for example, in an intelligence agency were if an intelligence agency were to obtain intelligence indicating that a classified document in the seized materials might have been compromised, the FBI would be responsible for taking some of the necessary steps to evaluate that risk. So they give an example of why this is potentially harmful and why they need to then investigate criminally. So they give an example of why they would need to do criminal. So it's not necessary that the criminology would be associated to the plaintiff. It's just that they need to be able to do a full investigation. And as each day ticks by, they can't conduct a thorough investigation. Not only that, but as a practical matter, this guy Kohler explained the same senior Department of Justice and FBI officials such as Kohler are ultimately responsible for supervising the criminal investigation and for ensuring that the FBI is coordinating appropriately with the rest of the intelligence community on its classification, review, and assessment. They saying they need to make sure the integrity of their information is sound. Then the plaintiff responded that there still remains a disagreement as to the classification status of the documents. This is amazing stuff right here. He emphasizes that the special master review was temporary and asserted that he had a statutory right to access the documents. On September 15th, the district court denied the stay pending appeal, and that's why we're here with this decision, and appointed a special master. In explaining the basis for its decision, it being the lower court, the district court first reasoned that it was not prepared to accept, without further review by a special master, that approximately 100 documents isolated by the government were classified government records. Second, the district court declined to accept the United States argument that it was impossible that plaintiff could assert a privilege for some of the documents being classified markings. Yeah, you can't, like they say, classified. You can't say it belongs to you. You are not the classified thing. The next day, the United States moved in this court for a partial stay pending appeal, seeking to stay the district court's orders. With respect to only the roughly 100 documents bearing classification marks. Based on the United States contention that these documents and the corresponding criminal investigation are essentially in the government's effort to identify and mitigate potential national security. National security risks. The United States asks this court to act on its motion as soon as practical. All right. So then the court asks the plaintiff, we direct the plaintiff to file an expedited response to the United States motion for a partial stay. And the plaintiff responded, 1, we lack jurisdiction over the order appointing a special master. This is a joke. 2, he has Rule 41 standing. 3, the United States has not proved that the documents that are marked classified are actually classified. I'll agree with that point. And 4, the district court properly balanced the harms in enjoining the United States. So it's saying that in stopping the United States from investigating criminally, that the lower court, the district court, properly balanced that. So the United States replied that plaintiff's jurisdictional argument lacks merit. I agree, and I told you why. The appellate court is in the 11th district, in the 11th circuit, and the district court in this case is within its jurisdiction. So that first one is a no-brainer. So it lacks merit. Number 2, the plaintiff lacks Rule 41 standing as it pertains to the classified documents. 3, the records bearing classification markings have no plausible cause for being privileged. And even if plaintiff had claimed to have classified, the United States would still need to access them. And 4, without a stay of the district court's order as it regards the classified documents, the government and the public would be irreparably harmed. And here's what the court said. We have carefully reviewed the parties' briefs and records. And they come up with the first one. We have appellate jurisdiction through 28 U.S.C., which provides courts of appeals with jurisdiction over interlocutory orders granting injunctions. And they cite the law. Number 2, when deciding whether to grant a stay pending appeal, we evaluated 4 factors. Whether the stay appellant, the stay applicant, has made a strong showing that he is likely to succeed on the merits. 2, whether the applicant will be irreparably injured absent a stay. 3, whether issuance of the stay will substantially injure the other party's interest in the proceeding. And 4, where the public interest lies. And they use the case called NKEN. This is what they base their decision on, is that case. And here we go. After considering the 4 factors, we conclude that the United States is entitled to a stay. So they don't beat around the bush. They tell you right up front, we are affirming our decision that we told you about 16 pages ago that it was. Okay, the United States has established a substantial likelihood of success on its merits. And then they tell you why. The United States argues that the district court likely erred in exercising its jurisdiction to enjoin the United States use of the classified documents in its criminal investigation, and to require the United States to submit the marked classified documents to a special master for review. We agree. This court, says that they have done that. Our binding precedent states that when a person seeks return of seized documents in pre-indictment cases, those actions are governed by equitable principles. So he's not been indicted and he's asking for his documents back before he gets indicted. There is something that covers it, and it's called equitable principles. Whether viewed as based on federal rule of criminal procedure or on the general equitable jurisdiction of the federal courts, Ritchie is used. So they already decided the issues related to the other dude, the name I spelled earlier. What is it? The NKEN. Now they are on to Ritchie. And as you recall, the district court went through 4 points in Ritchie. So now they're going to go through her 4 points. Here, while plaintiff disclaimed that his motion was for return of property as specified in Rule 41G, he asserted that equitable jurisdiction existed, and the district court relied on both Rule 41 and equitable jurisdiction in its orders. Whether a court should exercise its equitable jurisdiction in this context is subject to sound discretion of the district court. But this discretion is not boundless. So they're saying, yeah, it's at your discretion, baby boo, but you have limits. The factors a court should consider when deciding whether to exercise jurisdiction includes whether the government displayed a callous disregard for constitutional rights in seizing the materials at issue. 2, whether the plaintiff has an individual interest and need for the materials, right? And 3, whether the plaintiff would be irreparably injured by denial of the returned property. So will he be irreparably injured if he doesn't get the classified documents back? That's the underlying question. And 4, whether the plaintiff has an adequate remedy at law for the redress of his grievance. We consider each in turn. We began as the district court did, with the callous disregard, which is the foremost consideration in determining whether a court should exercise its equitable jurisdiction. Indeed, our precedent emphasizes the indispensability of an accurate allegation of callous disregard. Here, the district court concluded that plaintiff did not show that the United States acted in callous disregard of his constitutional rights. The absence of this factor in Ritchie's analysis is reason enough to conclude that the district court abused its discretion in exercising equitable jurisdiction here. Remember I said earlier, you just finished saying he didn't they did this in a lawful manner. So how did they violate him? And I said, I don't know if you could just go on from there if you didn't meet one of the factors. So, listen to what the court says. But for the sake of completeness, so normally if you don't meet a factor, it can end there. But they went forward to say, for the sake of completeness, we consider the remaining factors. The second Ricci factor includes whether the plaintiff has an individual interest in the need for the materials whose return he seeks. So does he have a need for these documents? And here's what the district court concluded: that the plaintiff had an interest in some of the seized material because it included medical documents, correspondence related to taxes, and account information. But none of those concerns apply to the roughly 100 classified documents at issue here. And the district court made no mention in its analysis of this factor as to why or how plaintiff might have an individual interest in or need for the classified documents. Sometimes people just do mic drop. For our part, we cannot discern why plaintiff would have an individual interest in or need for any of the 100 documents with classification markings. Classified documents are marked to show that they are classified. For instance, with their classification level. So they are owned by, produced by, or for, or under the control of the United States government. You know those things called classified documents. That's what they're talking about. And they include information the unauthorized disclosure of which could reasonably be expected to cause identifiable or describable damage to the national security. For this reason, a person may have access to classified information only if, among other requirements, he has a need to know the information. So back to Glib's earlier statement in the chat that the president can have access to this information. The question is, why does he need to know if he's no longer the presidente? That part, that's a question for you, Glib. Why does he need to know if he's no longer the president? The requirement pertains equally to former presidents unless the current administration, in its discretion, chooses to waive that requirement. Let me just reinforce that again, because it came up in the questions in my chat, and I just want to make sure that it is abundantly clear. The requirement pertains equally to former presidents unless the current administration, in its discretion, chooses to waive that requirement. That is not an opinion. That is quoting whatever section 4.43 comes out of. And since it's an id, I'm going to think it comes out of the classified national security information. So if you know how to read citations, the id means it's coming from something previously. So I'm going to assume right now it's coming from the Classified National Security Information Executive Order number 13,526, section 1.6, 3 CFR 298. Yeah, those are citations, and that's telling you where it's coming from. Plaintiff has not even attempted to show that he has a need to know the information contained in the classified documents, nor has he established that the current administration has waived the requirement for these documents. And even if he had, so it's saying he hasn't done this, but let's just give him a hypothetical that he did. That in and of itself would not explain why plaintiff has an individual interest in the classified documents. Plaintiff suggests, listen to these words, suggests that he may have declassified these documents when he was president. But the record contains no evidence that any of these records were declassified. And before the special master, plaintiff resisted providing any evidence that he had declassified any of these documents. Now, I am a little concerned about that statement right there. But another day, another dollar. In the event, at least for these purposes, the declassification argument is a red herring, because declassifying an official document would not change its content or render it personal. Let's go through that again. Even if he declassified the document, it doesn't make it personal to him. That's basically what they said. So they shut down the whole declassification argument. They're saying, sir, we don't give a fluting any if you declassify these documents. They don't belong to you. They're not personally yours. You may have an argument that they're no longer classified documents, but they're still not yours to be returned to you because the contents of it belongs to somebody else. It's not yours. The problem in this world, not only doesn't he have closure, but he's no respecter of another person's property because he thought he was a god. Moving on. This factor, the plaintiff's personal interest or lack thereof in the documents also weighs against exercising jurisdiction. He has no jurisdiction over the documents. Third, Enrichi asks whether the plaintiff would be irreparably injured by denial to the return of the property. The district court identified potential harm that could arise based on improper disclosure of sensitive information to the public that could arise. The United States retention and use of the privileged materials, and 3, the stigma associated with future prosecution. Listen to what the court said. We cannot conclude that plaintiff would be irreparably injured by a stay regarding the documents marked classified. Because they're not his. Plaintiff suggests that he could be harmed by the disclosure of sensitive information. Him and the classified documents are not one, is what they're saying. But permitting the United States to retain the documents does not suggest that they will be released. Indeed, a purpose of the United States' efforts in investigating the recovered classified documents is to limit unauthorized disclosure of the information they contain. So is he saying the classified documents are about him? Not only that, but any authorized official who makes, and this is a poignant point, improper disclosure risks her own criminal liability. Any authorized official who makes an improper disclosure risks her own criminal liability. We also doubt. So the court now has doubts. The plaintiff's risk irreparably injury. That the plaintiff's irreparable injury in the form of disclosure of privileged information. He has not, for example, asserted attorney-client privilege over any of the classified documents. The remaining potential injury identified by the district court is the threat of future prosecution and the series. And this is like one of these moments when you be like, maybe this judge needs to go back to law school. Oh, I forgot she was appointed during this period of time when they were just putting people who were not qualified to be on the bench on the bench. This might be an example of not being qualified at its forefront. The remaining potential injury identified by the district court is the threat of future prosecution. No doubt the threat of prosecution can weigh heavily on the mind of someone under investigation. So they're not trying to marginalize his concern or the plaintiff's concern for a criminal investigation, but without diminishing the seriousness of that burden. So they're very polite to him. Look how polite law could be. If the mere threat of prosecution were allowed to constitute irreparable harm, every potential defendant could point to the same harm and invoke the equitable powers of the district court. That means everybody that's charged with something could say, listen, I could be charged with this. You need to stop investigating stuff so I don't get charged. Where they do that at? Anyway, if this concern were sufficient to constitute irreparable harm, so this is like smack this judge down. This is like one of those Monica's moments. Smack your chick and tell you ain't having it. The court said, like, wait a minute, judge, slow down. If this concern was sufficient to constitute irreparable harm, courts exercise over their equitable jurisdiction would not be extraordinary, but instead quite ordinary. It is a familiar rule that courts of equity do not ordinarily restrain criminal prosecution. In sum, the third factor also weighs against exercising equitable jurisdiction. Finally, Ritchie asks whether the plaintiff has an equitable remedy at law for the redress of his grievance. So the factors that she was considering, right? It says, does he have a remedy? Does he have a solution? That's what remedy is to the court. Does he have a what's the relief? What could he get? The district court found that the factor weighed in favor of the plaintiff because plaintiff would have no legal means of seeking the return of his property for the time being. But plaintiff has been clear that he is not seeking the return of the classified documents. And even if he were, see, all of this stuff, this has to do with another court case. This is what they're quoting. This part right here is what they're quoting. It's not part of their response. This is them quoting law. Their response is saying, and even if he were, he has not identified any reason that he is entitled to them. So they said the plaintiff has been clear that he is seeking the return, has been clear that he is not seeking the return of the classified documents. And even if he were, he has not identified any reason that he is entitled to them. This factor then also weighs against exercising equitable jurisdiction. In sum, none of the Ritchie factors favor exercising equitable jurisdiction over this case. So the finding of the appellate court was that none of the factors and every rationale that the lower court benefit that she gave to the plaintiff in this matter was wrong. So in sum, none of the factors favor exercising equitable jurisdiction over this case. Consequently, the United States is substantially likely to succeed in showing that the district court abused its discretion in exercising jurisdiction over plaintiff's motion as it concerns the classified documents. Okay, so now they just finished considering if the plaintiff is harmed. So now they go and they consider, is the defendant harmed, which is the United States. And it says, we next consider the second NKEN factor, whether the United States would suffer irreparable injury in the absence of a stay. The motion for a partial stay, and they said, we conclude it would. I don't want to highlight it because you know what will happen. Okay. The motion for a partial stay distinguishes the roughly 100 seized records with classification markings from the remaining seized materials without any such markings. Because the classified nature of these documents bears on our analysis, we begin with a brief review of the United States system of classification. Booyate, booyate, booyate. I was just sitting here reading this like, oh, this is like a good book to me, right? Since World War I, look, they took it all the way back. They took it back to World War I. The executive branch has engaged in efforts to protect national security information by means of a classification system, grading according to sensitivity. In practice, presidents have often used executive orders to protect sensitive information and to ensure its proper classification through the executive branch. The current operative classification protocols are described in the Executive Order 13-526. Under Executive Order 13-526, there are 3 classification levels. See how beautiful this is? Confidential, secret, and top secret. The standard for the level at which particular information should be classified turns on whether, quote, the unauthorized disclosure, end quote, of the information, quote, reasonably could be expected to cause either damage. And then they give you the levels. Damage, which is confidential. Serious damage, which is secret. Or exceptionally grave damage, which is top secret. So if the unauthorized disclosure of the information reasonably could be expected to cause damage, serious damage, or exceptionally grave damage, confidential, secret, top secret, to national security. Once so designated, classified materials may remain classified up to 10 years unless the original classification authority determines that the duration should be 25 years. So there is they go on to describe that process here. Classified records are also subject to automatic So a classified record can become automatically declassified if they are more than 25 years old and have permanent historical value, unless they fall into certain enumerated categories, which we're not going to discuss today. And they didn't either. They said, returning to the case before us, under the terms of the district court's injunction, the Office of the Director of National Intelligence is permitted to continue its classification review to access the potential risk to national security that would result from disclosure of the seized materials. But the United States is enjoined, prohibited, injunction, from further review and use of any of the materials seized from plaintiff's residence on August 8, 2022 for criminal investigative purposes pending resolution of the Special Masters Review process. This distinction is untenable. UNTENABLE. How do you get woo to the judge? This distinction is untenable. Through Kohler's declaration, the United States has sufficiently explained how and why its national security review is intertwined. It's intricately intertwined with its criminal investigation. So they connected there. When matters of national security are involved, we must accord substantial weight to the agency's affidavit. This is not quoting a judge. This is in deference to what that district judge said. See this? This is a citation of a case called Broward Bulldog, Inc. versus U.S. Department of Justice. That's what it said in that case. When matters of national security are involved, we must accord substantial weight to an agency's affidavit, not to a former president, but to an agency's statements, to what the agencies say that it is, because it's matters of national security. And here's the law that supports that activity. Moving on. The ingrained principle that courts must exercise the traditional reluctance to intrude upon the authority of the executive in military and national security affairs guides our review of the United States proffered national security concerns. No party has offered anything beyond speculation. So listen to what they said. This has now just become speculation. To undermine the United States representation supported by sworn testimony. So hear what they're saying. No party has offered anything beyond speculation to undermine the United States representation. So it's speculation here. Supported by sworn testimony, they don't have none of that. The findings from a criminal investigation may be critical to its national security review. According to the United States, the criminal investigation will seek to determine, among other things, the identity of anyone who accessed the classified materials, whether any particular classified materials were compromised. So this will explain why attorneys started getting attorneys, on here whether any particular classified materials were compromised and whether additional classified materials may be unaccounted for. As plaintiff acknowledges, now this is the plaintiff saying this, backwards looking inquiries are the domain of the criminal investigations. Okay. In order to have a criminal investigation in most cases, it begins looking back at things because a crime has occurred, means that it had happened. So if a crime occurred, of course you would be looking backwards to reenact or reconstruct what occurred so that you can bring up charges. That's why they do investigations. Like this was like mind-boggling to me. Okay. It would be difficult, if not impossible, for the United States to answer these critical questions if its criminal investigators are not permitted to review the seized classified material. Precisely because the United States criminal investigation is focused on past events. Plaintiff responds that the United States is not irreparably harmed because it can be distinguished from prospective national security review. They're like, I don't know what this argument is, but we were not persuaded. So if that was your persuasive argument that they have the ability to investigate whatever they want to investigate or whatever, yeah, move on. The United States explains that there are circumstances where its national security assessment of the classified materials is intricately entwined with the criminal investigation. Thus, an injunction delaying or perhaps preventing the United States criminal investigation from using classified materials risks imposing real and significant harm to the United States and the public. The United States also argues that allowing the Special Masters and Plaintiffs' Counsel to examine the classified records would separately impose irreparable harm. And the court said, we agree. And again, I stated this earlier, they throw this in, I think, as a we agree. And the Supreme Court has recognized that for reasons too obvious to call for enlarged discussion, the protection of classified information must be committed to the broad discretion of the agency responsible, and this must include broad discretion to determine who may have access to it. That's why I don't understand why the current president would give that right to the National Archives people. As a result, courts should order review of such materials in only the most extraordinary circumstances. The record does not allow for the conclusion that this is such a circumstance. This is not in their view an extraordinary circumstance. In sum, given the long recognized compelling interest in protecting the secrecy of information important to our national security, and they quote a case, Sneap versus the United States, we conclude that the United States would suffer irreparable harm from the district court's restriction on its access to this narrow and potentially critical set of materials, as well as the court's requirement that the United States submit the classified records to the special master for review. We next turn to this other factor again, the NKEN, And here we analyze whether plaintiff would be substantially injured by the stay. Largely for reasons we have already discussed, we conclude that he would not. First, we've explained that the plaintiff does not have possessory interest in the documents at issue, so he does not suffer a harm if the United States reviews documents he neither owns nor has a personal interest in. 2, we find unpersuasive plaintiff's insistence that he would be harmed by a criminal investigation, bearing the discomfiture and cost of a prosecution for a crime even by an innocent person is one of the painful obligations of citizenship. And they quote, that's coming from a court case. Third, because of the nature of the classified materials as at issue, here, and based on the record, we have no reason to expect that the United States' use of these records impose the risk of disclosure to the United States of plaintiff's privileged information. Given the limited scope of the stay, applying to only appropriately 100 classified documents, we conclude that plaintiff has not shown he will be substantially injured by a stay. We now come to the fourth and final factor, where the public interest lies. The documents at issue contain information, the unauthorized disclosure of which reasonably could be expected to cause exceptionally grave damage to the national security. For these reasons, we have explained we grant the stay pending appeal. The district court order is stayed in the event it enjoins the government's use of the classified document and requires the government to submit the classified documents to the special master for review. So that's where we are. Now I understand it much better. Give me something to read and I can go from there. Again, I don't think I've had any arguments with anybody that was for this man having the documents. But I think what I have had discussions about is understanding how we got to the point that we're in, and or how we get an understanding of what transpired in court. And as you recall, that was the basis of how I formulated building my channel here. When I've moved over to the justice part of things, I wanted to give the court a 360-degree look into what was happening. I wanted to see cases based on what was presented in the court, what you had to determine based on what the court has before it, and what your decisions would be about it. And that's the only discussion point that I want to engage in. There's a lot of unhealthy dialogue about that administration from his arrival. And I'm closing this on my conversation of closure. When I first came to the internet in 2017 and discovered this internet, it's because I was running away from conversations in my real, I'm not gonna say in my real life, in my personal life with real people, not people on the internet. And we had just come off of an election in 2016. And folks were angry and bitter that we had gotten this dude as president, 45. And they spent day and night and day, watching MSNBC and the likes, disgruntled about the process. And the more I listened to people angrily belch about the new president, Trump, I began to discover that they didn't even vote. And I started to say, you cannot take audience with me on that discussion because you waived your right to vote. You are part of the problem. And I listen to people banter back and forth why they won't vote. And all I could remind them is, this is why you got the president you got. My conversation started to turn. And by the time we got to 2020, this man's reign of terror had us in a pandemic that he could not control because he hadn't put in the infrastructure in place to do so. So yes, I could be frustrated with everyone else, and I could want closure for that man's administration. But I know that this is a pause on the direction that we see ourselves as a community or as a people or as a nation. At the end of the day, we have to own our mistakes. He may have been one of the most monumental mistakes in that office, but it all served a purpose. It served a learning purpose for each of us. And if you are determined that you want to sit around and bellow and be angry that you had an administration in place that did nothing that was conducive for you for 4 years, and you've been doing this for 2 years, it's the same reason why I ran in 2017 away from those discussions. Because I was tired of listening to people that had an opportunity to erect change and chose cowardly not to sit around here complain. And I understood then that you would encounter people who have the power and relinquish their power every day to somebody else. You are your own boss. Own it. You are your own boss. Own it. No one controls your emotions and how you navigate life unless you allow them to. Close off some of these relationships that don't matter. They're not adding purpose to your everyday focus. They are a distraction to your success. And every day that you allow them to distract from you being the best you, it's unfortunate for you. They're achieving what they want to achieve. They say misery loves company. And they have a lot of fans, targets. Put closure on them. Make a pause moment to reevaluate what you want in your life and where you want to go. Because see, as in 45, he couldn't let go of the power that he received. And when he couldn't let go of the power that he received, it overwhelms him that he thought he could just take it. He thought he had inalienable rights that never even existed, but only in his head. This week I saw them go and take the last ceremony in that queen's burial was the removal of the rod. Girl, wait a second, because I had to text my T-Money. I was like, wait a second. They had to remove stuff. They removed the crown. The crown was the last one. It was the sword first. It was the globe second, whatever the ball thing was. And then it was the hat. The hat. Y'all know I done reduced stuff down to its littlest purpose. But then there was the crown. And as the person in the church was talking about taking away her power, the power in the rod, what it represented and symbolized, the power in the globe, what it represented and symbolized, and the power in his hat. All of that represented some false sense of power over people that somebody inalienably has. How is that even possible? Man, oh man, idolize no one. And I came here in 18 saying the same thing. Don't make me no idol. Don't love me and all of this other false worship and make me into no goddess for you. You are all precious in your own right. Put some closure on some of the nonsense. And I know that people still target me in their inner trappings here because folks feel that they're on your bandwave of success instead of living on their own bandwave of success. I don't know what else to tell you. I'm going to do my best. I'm going to be impeccable with my word. I am going to stay focused on the things that are true to me. I'm not going to assume that I understand your destiny, and I hope that you stop trying to pretend like you understand minds. And I'm not going to take this stuff personal. Too many other things happen in your day-to-day that are really personal, that you can spend time taking that personal. What goes on in your misery is not going to make me eat. And with that being said, stay motivated. Today's broadcast was brought to you by the M and the O. Mo.